In April 2024, the Auto Care Association published the results of a survey of 407 independent repair shops across the United States. The findings were unambiguous. 84% of independent shops identified vehicle repair and maintenance data access as the number one issue facing their business. 63% reported experiencing difficulties making routine repairs on a daily or weekly basis because of software and data access restrictions. 51% reported sending up to 5 vehicles per month directly to a dealership because their own diagnostic tools could not access what the manufacturer's system required to complete the repair. The average labor time an independent shop wasted trying to resolve a software-restricted repair before giving up was 2 to 4 hours. Those numbers describe what is already happening on trucks sitting in independent shops today, not a future regulation, not a proposed rule. The present reality on American roads in 2026, and the legislative, legal, and lobbying infrastructure being built around this present reality is designed to determine whether the person who owns and maintains their own truck will still have the legal standing to do so 5 years from now. Today we are documenting the complete and accurate picture of the right to repair battle as it actually stands in 2026. The laws that have passed, the lawsuits that have been filed and how they resolved, the lobbying dollars behind the opposition, the competing legislative proposals and what each one actually says, and what every truck owner who turns their own wrenches needs to understand before they buy their next vehicle. Part 1. What the problem actually is, and why it is getting worse with each model year. The issue is not that modern trucks are complicated. They have always been complicated. The issue is that manufacturers have moved the complication from the mechanical domain into the software domain, and software is governed by intellectual property law, not by mechanics. In the mechanical era, a technician who understood how a carburetor worked could buy a rebuild kit from any supplier and service any carburetor ever made. The principle was universal. The tools were universal. The knowledge was transferable. In the software era, a technician who understands how an engine control module works cannot access the proprietary calibration tables inside it without a manufacturer-issued software license. The principle is universal. The tools are not. The license is not transferable. It belongs to the manufacturer. And the manufacturer decides who gets it, on what terms, and for how long. Component serialization makes the problem structural. On modern trucks built after approximately 2018, replacement parts carry individual digital serial numbers assigned at the factory. The body control module checks those numbers at startup. If a replacement part's serial number is not registered to the vehicle's VIN in the manufacturer's server database, the module rejects the part. A physically functioning part, correct application, correct installation, rejected by software. The repair that cost $40 and 30 minutes at any auto parts store in 2005 now requires a dealer visit, a software authorization, and a fee that can reach several $100s before a single mechanical repair is performed. This is not a technical limitation. It is a business architecture decision. The manufacturer chose to build the vehicle this way. The manufacturer controls who can work on it as a result. Part 2. Massachusetts in the 5-year legal battle that finally ended on February 11, 2025. In November 2020, Massachusetts voters approved a ballot initiative that expanded the state's automotive right to repair law. The measure passed by a roughly 3-to-1 margin. The law required that beginning with the 2022 model year, Vehicles sold in Massachusetts that utilize a telematics system must be equipped with an interoperable, standardized, and open access platform enabling customers and independent repair shops to access mechanical data from those systems. Within days of the ballot measure passing, the Alliance for Automotive Innovation filed a federal lawsuit against the Massachusetts Attorney General. The Alliance for Automotive Innovation is the lobbying organization whose members include Ford, General Motors, Toyota, Honda, Hyundai, Nissan, Mercedes-Benz, Stellantis, Volkswagen, and Kia. The lawsuit argued that the Massachusetts law was preempted by federal vehicle safety laws and created unacceptable cybersecurity risks. The case was assigned to U.S. District Court Judge Douglas Woodlock. A full bench trial was held in June 2021. Judge Woodlock never issued a ruling. The case sat for over 3 years. In January 2025, the case was reassigned to U.S. District Court Judge Denise Casper, who announced her intention to resolve it quickly. On February 11, 2025, Judge Casper dismissed the final 2 counts of the lawsuit. The Massachusetts Data Access Law survived every legal challenge the automotive lobby brought against it. The Boston Globe reported directly that if history repeats itself, referring to the 2012 right to repair law that Massachusetts passed, and automakers then agreed to meet nationally, the Massachusetts law could once again become the de facto standard for automotive data sharing across the country. The Alliance for Automotive Innovation's response was to state publicly that some vehicles may no longer be offered for sale in Massachusetts as a result of the ruling. Not that they would comply, that they might stop selling cars there. That is the level of resistance the automotive lobby is willing to bring to preserve control over repair data. Part 3. The lobbying operation and its documented cost. The Alliance for Automotive Innovation is the most active automotive industry lobby in Washington. According to Open Secrets, the organization spent $4,766,000 lobbying in 2024. In 2025, through September, the organization had already spent $7,831,000. A Senator Warren letter to automakers cited Vice reporting that the auto industry spent $25 million lobbying against the Massachusetts right to repair ballot measure alone in 2020. Of the 23 lobbyists the Alliance employed in 2024, 19 had previously held government jobs. That revolving door between the manufacturer's lobby and the regulatory agencies that govern those manufacturers is not incidental to the outcome of the right to repair debate. It is a structural feature of how the debate is being conducted. Part 4. The Repair Act, the Safe Repair Act, and the legislative fight in 2025 and 2026. In February 2025, the Right to Equitable and Professional Auto Industry Repair Act, known as the Repair Act, was reintroduced in the House as H.R. 1566. In April 2025, it was introduced in the Senate as S. 1379. According to Congress.gov, the bill would require automakers to provide independent repair facilities with access to diagnostic codes, calibration tools, and essential repair information. The bill includes a key preemption provision. Section 8 of H.R. 1566 states directly that a state may not maintain, enforce, or continue in effect any law covered by any provision of this act. This means the Repair Act would supersede the Massachusetts Data Access Law, the main automotive right to repair ballot measure, and every state-level automotive repair access law that has been passed or is being litigated. Supporters argue this federal clarity prevents a fragmented state-by-state system. Critics including NADA, the National Automobile Dealers Association, argue the bill is unnecessary because the 2014 Memorandum of Understanding between automakers and independent repairers already provides the access that independent shops need. As of April 2026, H.R. 1566 has not passed. It is not law. In February 2025, the Alliance for Automotive Innovation jointly announced with the Automotive Service Association and the Society of Collision Repair Specialists the Safety as First Emphasis Repair Act, known as the Safe Repair Act. This competing proposal also establishes repair data access, but with provisions that the manufacturers prefer over the Repair Act language. The Safe Repair Act has not been introduced as formal legislation as of April 2026. It exists as a proposal backed by the industry lobby. The legislative situation in 2026 is therefore two competing bills, neither of which has passed. One proposed law backed by independent repair advocates, and one proposed law backed by the manufacturers whose repair monopoly the advocates are trying to break. Part 5. The state-by-state patchwork in Colorado's January 2026 law. While the federal legislative fight stalls, states are acting independently. According to PIRG's Right to Repair Tracker and Reed Smith's March 2025 analysis, the states that have enacted some form of right to repair law include Massachusetts, New York, Colorado, California, Oregon, Minnesota, and Maine. The laws vary significantly in scope and applicability. Colorado's broad digital right to repair law, enacted in 2024 and effective January 1, 2026, is described by Reed Smith as likely the broadest repair law enacted to date. Colorado's law specifically prohibits manufacturers of digital equipment from using parts pairing to prevent an independent repair provider or owner from installing an otherwise functional replacement part. It prohibits using parts pairing to reduce the functionality of equipment after an independent repair. And it prohibits using parts pairing to cause equipment to display misleading alerts about unidentified parts. Violations are treated as deceptive trade practices with civil liability of up to $20,000 per violation. However, Colorado's law explicitly exempts motor vehicles. The broadest right to repair law in the nation as of January 1, 2026, does not cover the truck in your driveway. The Repair Association's 2026 legislative template identifies motor vehicles as a recommended exclusion while allowing states to address additional categories as appropriate. The Repair Association advocates for right to repair legislation across all categories. Their own template recommends that motor vehicles be specifically excluded from state digital right to repair laws. This is because the automotive right to repair framework is considered a separate and more complex domain requiring vehicle-specific legislation rather than general digital electronics repair law. The complexity of that separation is part of what keeps the automotive right to repair fight years behind the consumer electronics right to repair fight. Part 6. The John Deere parallel and what it means for trucks. The most documented case study in the right to repair landscape involves not a truck manufacturer, but a tractor manufacturer, and it is directly relevant because it shows the endpoint of the current trajectory. In January 2025, the Federal Trade Commission filed a lawsuit against John Deere, alleging that Deere makes the only fully functional software repair tool capable of performing all repairs and then limited that tool to dealerships. The feces complaint was supported by PIRG and 11 farming organizations who had filed an original complaint with the agency in 2022. In October 2024, court documents revealed the FTC had opened an investigation for, quote, unfair, deceptive, anti-competitive, collusive, coercive, predatory, exploitative, or exclusionary acts or practices. John Deere's situation today is the documented future of the truck market if the current trajectory is not reversed. A proprietary diagnostic tool available only at the dealership. A software key held by the manufacturer required to authorize any repair on equipment the customer purchased. an independent repair market locked out not by physical access, but by software permission. The FTC saw enough in the John Deere situation to file a lawsuit in January 2025. The automotive version of that situation is what the Auto Care Association documented in its April 2024 survey of 407 shops. The survey numbers in the FTC lawsuit are describing the same system in two different product categories. Part 7. What smart truck owners need to understand right now. The right to repair fight is being decided in courts, in Congress, and in state legislatures simultaneously. None of those fights has been definitively resolved. The Massachusetts law survived its legal challenge on February 11th, 2025. The Repair Act has not passed as of April 2026. The Colorado law excludes motor vehicles. The manufacturer lobby spent nearly $8 million lobbying in 2025. The alliance stated publicly it may stop selling certain vehicles in Massachusetts rather than comply with the data access requirement the court upheld. You might think this fight does not affect you if you drive a pre-2018 truck and do your own repairs in your own driveway. It affects every decision you will make about the next truck you buy, because the vehicle you buy in the next model year is the vehicle being shaped right now by whichever side wins the legislative and legal battles described in this video. If the Repair Act passes, independent shops get guaranteed access to diagnostic and calibration data, component serialization practices that block independent repair face legal challenge. If the Safe Repair Act or no law passes, the 2014 MU and the 2023 voluntary commitment remain the operative framework. Voluntary commitments that the manufacturer can modify at any time. Voluntary commitments that the Auto Care Association survey documents are already producing 63% of shops struggling daily with software access restrictions. A commitment that is voluntary can be honored when it is convenient and ignored when it is not. That is not a right. That is a privilege, and privileges disappear. The Auto Care Association survey, the Massachusetts legal battle, the FTC action against John Deere, the lobbying dollars, the competing bills, all of it points in the same direction. Your truck's repairability is not a technical question. It is a legal question. And the legal answer is being written right now in a courthouse in Boston, in committee rooms on Capitol Hill, and in lobbying meetings at the Alliance for Automotive Innovation. Have you been blocked from repairing your own truck by a software wall that required a dealer visit to resolve? What was the vehicle, and what did they charge you to do something you could have done yourself? Sound off in the comments below, because your experience is the documentation that the Auto Care Association is citing in its testimony to Congress. If you refuse to let a voluntary manufacturer commitment stand between you and the right to fix what you own, hit the subscribe button and join the resistance. Keep the old iron running. Keep turning your own wrenches, and we will see you in the next one.